Right, hello everybody, and welcome to our Women in Sectional Title webinar. Thank you to the ladies who've just joined us for the first time. I do hope that you're going to find this webinar valuable. We're here to share information and to really grow our dynamic sectional title community. We have women who are estate agents, managing agents, trustees, owners, and we really enjoy our community. So yeah, hope you do enjoy it. Right, so October is a month buzzing with activities in Gauteng. We have a design exhibition, and in Cape Town we have got major cultural events, and it's really heartening to see that women are at front and center of these events. They are thriving, they're engaging, and the themes are activity and certainly visibility for women, which we're really happy about here at Women in Sectional Title. October is also a rich month for our own sectional title community. We have our community scheme ombud service in Durban, which is taking place on the 23rd and 24th this week at River Sands in 4 ways. And I think certainly if you are around, it would be very worthwhile to go and have a look at what's happening there. I'd like to thank our main sponsor, We Connect You. We really appreciate the opportunity that you give us to be on this platform, as well as all our managing agents. If you go to our sponsorship page, you'll see all the managing agents that support women in sectional title. And that's certainly the way that we need to work going forward, so that we have sustainability for this website. So if you are interested in supporting us, please do email me on marina@bbmlaw.co.za. Right, today we're talking trustee truth, the reality behind the role. And I think it's really quite important, because we know that being a trustee is such a really big responsibility. I'm just going to share my screen. I've given you some nice flowers today, so that you get a little bit of a different look and feel. So you want to be a trustee? Yes, well, that's the question that so many people are being asked at this stage. And never before in my career have I been asked so many times by trustees to say, look, we're actually tired of this role. It's too much work, there's too much effort involved. We don't have enough knowledge. And isn't there anything else we can do? And certainly that is the role of the executive managing agent, is becoming more and more important. But during this webinar, I'd like to make it very clear that I feel that we honestly and truly need to have the role of this managing agent. We have to have the role of the managing agent. I think it's very important, and trustees need to report to managing agents, and managing agents need to embrace the role of trustees, and they themselves need to embrace their own role. I think it's really important. Let me just go into the next. Sorry, there we go. So on points of clarity for this webinar, I need to talk about the concept of servant leadership when it comes to being a trustee. We're going to go through fiduciary duty as per the Companies Act, and then later we're going to apply that to sectional title. And we're going to look at the legislative prescriptions. These are the sections of the Sectional Title Schemes Management Act that you can always look at as a basis whenever you're talking to your trustees. That's section 3, 4, 5, and 7 of the Act. And then we're talking about where do we have to have owner involvement in decision making? So in other words, where can trustees make their own decisions, and where's the line drawn as to when you've got to revert back to owners? Because that is a point that sometimes trustees aren't really that great at knowing, or maybe they ignore it, I'm not sure. So the best trustees, in my view, are servant leaders. They're people who lead by serving others first. Servant leadership is rooted in humility, empathy, and a deep desire to make a positive difference. So it's the mindset that says, how can I help my community to thrive, rather than what can I get out of this role? Now, fiduciary duty is always the terminology that we use with trustees to say you've got a fiduciary duty to act in a certain way. And although the Companies Act doesn't apply directly to sectional title, The Companies Act is where the wording comes from, fiduciary duty, and it refers to the legal duty of trustees to act honestly, and obviously this is directors as well of companies, honestly, in good faith, and in the best interests of the scheme. Trustees must perform their functions in good faith and for a proper purpose, and must exercise care, skill, and diligence, never exceeding their powers. Okay, we're going to go into that in more detail. Over and above the trustee's fiduciary duty, you can always hang your hat on Regulation 14 of the Community Schemes Ombuds Service Act. And this is something I've got at my desk. I send it often to my clients, to the trustees, just to embolden them when they are in front of owners, to say, this is what I have to do. And this act, the regulation says, it talks about a scheme executive. So that means a director or a trustee in a sectional title scheme or a homeowners association. A scheme executive must take reasonable steps to inform and educate himself or herself about the community scheme, its affairs and activities, and the legislation and governance documentation in terms of which the community scheme operates. So this is really a beautiful way of saying ignorance of the law is no excuse. And I think that's what a lot of people are fighting about at the moment, or fighting against as trustees, to say we've got busy days, we really, can't understand the act in one go. And Regulation 14 goes on to say, the scheme executive must take reasonable steps to obtain sufficient information and advice about all matters to be decided by the scheme executives to enable him or her to make conscientious and informed decisions. In my mantra in life is that in anything, whatever you do, you need to surround yourself with expert opinions, with people who understand. So if it's a plumber, you need a proper expert plumber with a good reputation. If it's an attorney, then it should be specialist attorneys. And I think that stands a person in good stead, because I'm sure a lot of our portfolio managers will resonate with this. Whenever I'm consulting in a sectional title capacity on things like that need experts, like water ingress or whatever, it's just amazing how trustees have suddenly become experts in all these fields. Not only are they CEOs of their own company, but all of a sudden they understand water ingress and, understand how a structural engineer's report works. So in anything, wherever you have problems as a managing agent or a trustee in a building, remember that the very best thing that you can do is to obtain information and advice about all matters to be decided by the scheme executives. And you'll see now in the next while, I'm going to say to you that as trustees are entitled to appoint experts and agents and employees who give them what they need in terms of reporting. Sometimes they say, well, they weren't allowed to appoint you as an attorney because, for a real levy collection. In fact, trustees themselves are able to do that. They're able to appoint people. And again, you can whip out Regulation 14 here. Okay, so now we're looking at functions and duties of the trustees and their delegated authority. And this is Section 3 of the Sectional Titles Act. And if you have to go there, you'll say, yeah, but Marina, Section 3 says the body corporate shall carry out all these functions. Remember, in Section 7 of the Sectional Title Schemes Management Act, everything that I'm talking about now, the functions, the duties, the powers of the body corporate are delegated in Section 7. They're delegated to the trustees. So here we're talking about trustee duties, functions, and powers. So Section 3 says the trustees have the ability or have the right to establish a levy fund, and they call it an administrative levy fund. That is just your normal standard levy fund that you and I know that if I pay my levies, it goes into. They have to do that. They have to establish and maintain a reserve fund. We all understand the reserve fund, and they need to be certain about how that reserve fund works. How much money needs to go into that reserve fund and needs to be there at all times. After the year end, they need to check out and see what was in that reserve fund to be able to top it up. They've got to ensure that owners pay a contribution on all exclusive use areas. Now, I just want to put a pin in this because this is a question I get asked all the time as well. And the thesis have also raised a few questions about this exclusive use areas. Most of sectional title complexes that I'm aware of, the trustees do not charge an additional contribution for exclusive use areas. These are exclusive use areas which are either rule created or registered notarially, or neither of those. They're just utilized exclusively by people. It might be common property area. But all those areas should have a contribution levied on them, whether it be 200 Rand, 350 Rand, or I know in Cape Town, for example, they're much higher. They might be exclusive use area carports, which are in huge demand. But the formula for that exclusive use area contribution over and above the levies is not square meterage or market related value. It's to defray the costs of maintenance, to defray the costs of water and electricity if it's a garden, the water. So it's really a little bit of a thumbsuck, but trustees should be, and they actually have to. The word in the Act is must levy a contribution over and above the levy. And that's the way bodies corporate can bring in funds. They can bring in money like that. Trustees need to open bank accounts. We know, insure the building. Again, this one here, failure to insure the building falls under gross negligence. And I think that's really important. I mean, especially against fire, which is a legislative, it's compulsory in terms of the legislation. So if you're not insured, your building is not insured, the trustees there are going to get themselves into big trouble. Obviously, the biggest one and the one that covers the most issues that come across my desk, trustees have to maintain common property. And now in terms of the latest CSOS directives, you are not allowed as a set of trustees to delegate the responsibility in the rules, in your rules, for maintaining common property. So you can't say, well, in this scheme, there's a resolution that actually all owners are going to look after their own roofs, or all owners are going to paint the building. That's not on. Body corporate has to maintain common property at all time. In general, to control, this is the trustee's duty to control, manage, and administer the common property for the benefit of all owners. There's also a lovely catchphrase that we use in our legal letters to people to say that is the responsibility of the trustees. And if they don't do that, failure to do that, there are certainly consequences. And we'll be discussing those consequences in a minute. We're going to Section 4 of the Sectional Title Schemes Management Act. This now talks about powers of the trustees. Again, in terms of Section 7, delegated authority, where the body corporate delegates this responsibility directly onto the shoulders of the trustees. And here they have the power to appoint agents and employees. That's what we said. So no going back to anybody. Squarely on your shoulders. Acquire movable property for common property. So in other words, lawnmowers and equipment maybe for a very small little park, things like that. Anything that they need to acquire, they can do that. They can establish and maintain suitable lawns, gardens, and recreation facilities on common property. Now, this is quite a tricky one, I've found, because this gets a little bit close to the line where you're acting for reasonably necessary improvements on common property, where you actually need to go back to owners. So I think this is very basic stuff. If you just basic lawns, gardens, and maybe a little play park or whatever, but when you start going into the big bucks, into the big money, and you're wanting to put like something that looks like a botanical garden, or you want to put brilliant facilities onto common property, I think you might need to move away from trustees only doing that. But there we go. They have the power to invest monies into the levy fund, and they have to do all things necessary for the enforcement of the rules and for the management and administration of the common property. Big things. Trustees, the maintenance story, maintenance and enforcement of rules. To me, covers so much in sectional title. And I think, so let's just go again. I just want to harp on a little bit about maintenance. You'll get owners phoning you as an attorney to say, how can the trustees just go ahead and paint, or how can the trustees go ahead and raise a special levy, for example? They definitely can. Anytime that it's maintenance, they can do that. Anytime it's enforcement of the rules, they have to make that decision. And again, a set of robust trustees will always make that decision to enforce their rules, because otherwise they're left with a complex where owners just do what they want to do. You've got rules. Those rules that must have a compliance certificate, and one of the roles of the trustees is to enforce. And how do you enforce? You either go to CSOS, you either have internal mediation before you go to CSOS, obviously, or either you can go to court. You can still concurrently go to court on certain matters, although lately we have seen the courts push things back to the CSOS. Now, not only do you have Section 3 duties, Section 4 powers, you also have additional powers. But these additional powers, in terms of Section 5, mainly require owner involvement. Now, here's where you've got to go back to the owners. Before we look at the written consent of all owners, we must say that at every AGM, one of the agenda items we have is the bringing in of restrictions and directions. So all the owners at that AGM have the right and ability by ordinary resolution to say, you're not allowed to spend more money than 20,000 Rand without coming back to us. And that is something that we always look at before we give any legal advice. Are there restrictions and directions on the trustees? So that's the first point. Where we need the written consent of all owners is where you buy land outside the common property. And that is, for example, I had a matter where we had a lot of Jewish people in one of our complexes in Killarney, and they wanted to buy land right adjacent to them, which was being sold by the shul at that stage. And the body corporate really needed more land for parking. And they were successful. They got the written consent of every owner. They had monies to spend. I think they did raise a bit of a special levy, but that was where you needed the written consent of all owners. Also, where you're selling a right of extension of the scheme to third parties. So say, for example, you've got a development where you have the excuse me. Oh, sorry, something got in my throat here. Let me just have a sip of my coffee. Where you've got the developer who has basically lodged the right of extension of the scheme to a third, to extend, and you've got, thank you, and you've got the developer deciding at the last minute, which has happened a lot in Johannesburg, that they can't do it, they can't fix it, they can't finalize it. They want to sell to a third party, generally another developer. So what will happen with that is that they need to come back to the body corporate. The trustees can't give them the go-ahead to sell to another developer. So the trustees will have to get written consent from all the owners. A couple of others where you need written consent of all owners is where you need to change the use of a unit, where the use of that unit was maybe for residential purposes, and now you want to change it for business use. You need the written consent of all owners if the trustees don't give a special resolution to that effect. So that is also somewhere you need the written consent of all owners. Then we go to ordinary resolutions, where you need to go back to owners and you need 51% of the owners to agree to that ordinary resolution. To install separate meters, you need an ordinary resolution. To remunerate trustees who are not owners. So in other words, where, for example, if you wanted to appoint me as a trustee at your scheme, you could. I would definitely say no at the moment, but if you wanted to, that remuneration and you need to pay me, you would need to obtain an ordinary resolution, 51%, and that is by PQ. You do know that it's by PQ. So much of the voting is now on PQ. Even getting a quorum, you need a quorum on PQ. Appointing a managing agent, but trustees can also appoint managing agents, just so you know that it's either or. Special resolutions, that's why I put down the show of hands. The show of hands has lost popularity due to the amendments in the Sectional Title Schemes Management Act. So when you get a special resolution, you have to get that special resolution at 75%, we know, on number and value. So it's got to be on show of hands, but also on your PQ, on your value. And what do you need a special resolution for? You've got to go back to owners for this. If the trustees want to lease common property for less than 10 years, then they need a special resolution from the owners to do so. That's generally talking about carports in my experience very much. If you want to install prepaid meters, again, the trustees have got to have a special resolution for that. They've also got to go through, if they don't want to get a special resolution, then they have to send out a notification all about those prepaid meters, what it's going to cost going forward. There's a whole procedure for that as well. Special resolution is needed to borrow money, to create servitudes. If you want to create a right-of-way servitude over any area of your common property, you definitely need a special resolution. To extend a section. Again, a lot of people, trustees at this stage, in many of my complexes, particularly at the coast, seem to think that they can give permission for somebody to extend their section because it's only by, a very, very small square meterage. That's 100% incorrect. To extend a section, the person in the unit needs to obviously give the plans of that, and you need a special resolution before you go on to give it to the Surveyor General, who then approves, and then you've got to get the whole thing redrawn. It's another webinar, which I think we might need to do. All right, amending conduct rules. We all know this. Amending conduct rules is most important, and that is something, I think, with the consolidated directive from the CSOS, there are a lot more people who all of a sudden want their rules amended and want to understand what needs to be omitted, or what has been omitted and what needs to come in. I think that's important. But before you obtain your compliance certificate, you have to get a special resolution to amend rules. Trustees cannot do it on their own. Purchase, let, or sell a unit in the scheme. What I'm finding in our arrear levy practice is that more and more often body corporate is trying to purchase units, particularly where there is a huge amount of arrear levy coming to the fore, because that's honestly the only way. They can't get a sale, they can't sell it at a sale because there are no bids. So before anybody does that, and before the purchaser will allow even the sheriff will allow the body corporate to buy a unit on a sale and execution, they'll require special resolution from the body corporate to do that. Let also, if you need to let it out, to get levies in once you've purchased it as the body corporate, or sell. Maybe the body corporate decides that it's better now and there's a seller who's available and who wants that. Now, if you want to remunerate trustees who are owners, it's not an ordinary resolution like it was if you want to appoint an outsider like me to remunerate me. This also needs a special resolution. So I think that's quite self-explanatory. Then we go on to appoint an executive managing agent. You need a special resolution from the body corporate. Bondholders are also able to appoint executive managing agents. If you want to terminate a managing agent's contract on 2 months' notice, special resolution. I think that's the cleverest way to do that if you need to terminate a managing agent. Otherwise, the trustees can also terminate based on a breach of contract between the managing agent and the trustees. If you want to cancel a notarial or notarially registered exclusive use area, then it's not done very often, but you need a special resolution. And to effect reasonably necessary improvements on common property. Let's chat about that for a moment, because that's also something that comes up all the time. You'll remember that this fell under luxurious or non-luxurious improvements in the past. Now, reasonably necessary improvements are non-luxurious improvements. And there, that's Management Rule 29. You'll have a look at that. And where you want to look at doing that, Management Rule 29.2 says that if the body corporate wants to, if the trustees want to effect these kind of improvements, so for example, they want to place security intercoms or lighting, they need to set it out to the body corporate. They've got to say what the improvements are, how much the improvements are going to cost, what they're going to look like, and why they're necessary at all. And if I think it's a 30-day period to give the body corporate to owners to come back. And if the owners don't come back with that, then they can move on and effect those reasonably necessary improvements by themselves. They don't need to actually go and get a special resolution. If one person complains, and we all know there's always one, then you're going to have to go and have your meeting where you're going to get a special resolution and come out of that. So I think that's quite important. Let's move forward now to unanimous resolutions. So when we're talking unanimous resolutions, we know there needs to be an 80% quorum to obtain a unanimous resolution, and then everybody at that meeting needs to vote in favor in order to procure that unanimous resolution. So here, if trustees would like to sell common property, again, in your very large estates, you might have an area of the body corporate area of the common property which is not being utilized and which may be needed by the adjacent property. But here you need unanimity to do that. And that often doesn't happen. No, unanimous resolution often seems impossible to get because you just don't have like-minded people in one complex. If you want to lease land outside the body corporate, also unanimous resolution. If you lease common property out for more than 10 years, unanimous, create a registered exclusive use area. There's a little bit of confusion around registered exclusive use areas and rule created exclusive use areas with owners at the moment. They're not understanding how you can create exclusive use areas. If I was living in a complex, I would want my garden to be registered notarially so that I can take a bond out on it and nobody can ever take it away from me. And that's why I need a unanimous resolution to do that. If the one client yesterday said to me, "Oh, Marina, let's not go that route for a unanimous resolution. It's too much effort, and no, they're not going to give it to me. All I want is for this exclusive use area to be in the rules for me to be able to take over the maintenance of it." And that's a rule-created exclusive use through the conduct rules. We never used to be 100% certain about that. It was either the conduct rules or the management rules, but conduct rules require special resolution. To amend management rules, you need this kind of resolution. And why? Because your management rules contain the more serious type of stuff that you need to change. It's not the conduct rules, it's not the sort of daily operational running of those rules. When we deal with our developers who develop new complexes, at the very, very beginning, we amend those management rules, often to give the developer a different weighting in terms of the votes, and to give them specific access to certain things that they would not necessarily have had access to if they came, on board and then it needed to be done afterwards. So bear in mind, with very new developments, go and look at the management rules, because they're not all the time are they the prescribed management rules that you would get at the back of the Act. Unanimous resolution to loan money from own account. Hopefully nobody's doing that too much. Also, if trustees want to agree to extend the period of a Section 25 right to extend, you need a unanimous resolution. So we're just distinguishing that from selling your right to extend the scheme to a third party where you need a special the written consent of owners, to agreeing to extend the period of the right to extend. So I've got a matter now in the East Rand of Johannesburg where a developer had 20 years to build. And in 20 years, they haven't finished everything and they need now to extend that right. They're not going to get a unanimous resolution, possibly because there have been a lot of snags and problems with the first phase. So what happens if they don't get the right to extend through a unanimous resolution of the body corporate? What happens is that that property will now, that right to extend will vest in the body corporate, and the body corporate will then be able to take it on. And that has huge financial implications for a developer. So what can we do? Legally, we can take it to the CSOS and say to the CSOS, if there was a 51%, at least 51%, we could say to the CSOS, please, the Ombud has got the ability in terms of the legislation to substitute the decision of the body corporate, to take over from that those one or two people who wouldn't give us the decision, and to say, listen, for the benefit of the scheme, we definitely need the Ombud to take over the decision, as with special resolutions as well. So it's not the end of the road with these special and unanimous resolutions. Last unanimous resolution here is to effect not reasonably necessary improvements on common property. Also, it's not only to effect not reasonably or luxurious improvements on common property, but it's also to put the situation back or to rehabilitate. So, for example, complex we've got now is tennis court. They've got a tennis court. They want to take the tennis court down. So they want to. They can't just. The trustees can't just take the tennis court away. It took a unanimous resolution to put the tennis court there. It's going to take a unanimous resolution to place the situation back where there was no tennis court. Luxurious improvements depend on where your scheme is situated. Some things can be luxurious for some areas and not luxurious for others. But there will always be debates between owners about whether a swimming pool is a luxury or not. In my opinion, it definitely is. But then we've had a lot of fights about that with my colleagues. Okay, what I wanted to say to you now, because your trustees have got so much on their plates, they've got all these legal responsibilities and challenges. There is definitely going to be a time when they're faced with a situation where they're going to be sued for potential legal claims or for potential, they're going to have to put up a potential defense. And this is what's discouraging very much. It's discouraging a lot of trustees from running, because we're not going to be in a position where for every minute we're worried about what we're doing. If we were negligent, if we made an error, in good faith, what is going to happen? So what I'd like to just say to you first, I just want to go over fiduciary duties. I said I was coming back to it. In the Act, in Section 8 of the Sectional Title Schemes Management Act, it sets out fiduciary duties really properly. It says, each trustee of a body corporate must stand in a fiduciary relationship to the body corporate, must act obviously honestly and in good faith. We've taken that from the Companies Act. Must avoid any material conflict between his or her own interests and those of the body corporate. So you can't have your brother-in-law's landscaping company in the, use them. A trustee of a body corporate who acts in breach of his or her fiduciary relationship is liable to the body corporate for any loss suffered as a result thereof by the body corporate. That's what I want to just hone in on. Then the Act goes on to say that they are indemnified. Trustees are indemnified in terms of the Act, as long as they were acting in good faith. They weren't grossly negligent. That was the terminology before. They didn't breach their fiduciary duty in a way which would allow a court to hold them legally liable. So Professor van der Merwe says that the monies to indemnify trustees where they get sued legally for certain things, where they're acting in good faith and just making a few errors here and there, should come out of the administrative fund, the levy fund. So it's really incredibly important for bodies corporate to insure and to give indemnity insurance for these kind of situations. And I spoke to Mike Addison yesterday from AdSure, and he spoke about amounts of about 10 million rand for this kind of indemnity. I'm not talking about public liability where there is a legislative amount of no less than 10 million. But he's saying between 5 and 10 million is where you need to sit with this kind of indemnity insurance. So this indemnity insurance provides financial protection against claims and legal action. It excludes acts of fraud and dishonesty, just remember. Covers legal defense costs and potential damages claims, but only covers trustees in the bona fide execution of the trustee's duties within the scope of their authority. It must be sufficient for court high claims. That's why I mentioned to you the 10 million. It excludes gross negligence and willful misconduct. So that insurance situation, the example I gave you, there this insurance won't kick in because that's gross negligence. That's really of a high level negligence. It should cover all trustees. I've seen indemnity insurance which covers only the chairman, for example, shouldn't. And what we say here is indemnification insurance encourages people to stand as trustees. Let's give you a few real life examples of trustee indemnity that I've been thinking about. So if a trustee has overspent or went and didn't look at the directive and just said, well, we're spending 50 grand and we're not going back to owners to spend 50,000 rand on maintenance, for example. The indemnity cover will cover the legal defense and damages if they acted in good faith. Maybe they weren't aware or whatever, but that is an error that the law is allowed to forgive. If the trustees appoint an independent contractor, that contractor is really bad, and people have there's economic loss involved by owners, and they're coming to sue because they're saying that it led to problems in the scheme, the indemnity insurance will cover them. If, for example, a big one, if trustees are sued for harassment, because in enforcing their duties, the trustees have a lot to do with enforcement, and they've obviously got to write letters, they've got to take legal action, and very often your defendant will raise the fact that they're going to sue the trustees because the trustees are harassing them and not exceeding their legal duties. As long as the trustees are acting properly and not exceeding their authority or their duties, then the indemnity insurance will kick in. But you've also got to be a little bit careful because there's certain things which you need to look at in your insurance policy. Be cautioned. Check the policy wording of the insurance cover for this indemnification insurance. Often the insurance company will insist on a proper legal defense with reputable attorneys. There will be pre-warning notices which the trustees have to send to the insurers within specific time periods for the indemnification insurance to kick in. The coverage must align with the risk, and you need to check your limits on payout. So, and a few more things maybe. Under insurance, if the trustees haven't insured the building for proper replacement value, if they've done so in good faith and they've taken advice from the right people, they'll be protected. What about if an employee, like employment disputes, if an employee comes and sues the trustees for unfair dismissal, which is quite common, again, as long as they've followed the right procedures in terms of the Labour Relations Act, I think that's okay. They'll be protected. If they haven't maintained common property properly, but in all fairness, maybe there hasn't been enough money to do so, or they've had their reasons for delaying certain things in their maintenance, repair and replacement plan, the law would also probably take pity on them. Just to distinguish from other types of insurance, that's for trustees insurance. Obviously, fidelity insurance, we know, is a protection for the body corporates fund against theft or fraud or dishonest use of money by trustees. And we know that every body corporate has to have fidelity fund insurance. That's important. Public liability insurance as well, sometimes mixed up with trustee liability. So the body corporate must take out public liability for insurance. This will cover any liability that it may incur to pay compensation in respect of any bodily injury or death or illness of a person on or in connection with the common property, and compensation for any damage or loss to property that is sustained as a result of an occurrence or happening on common property. So the amount of cover must be determined at a general meeting and must not be less than 10 million rand. So that is definitely in the Act. So remember that before this insurance pays out, there must be legal liability on the part of the body corporate. So there has to be some sort of negligence, and that's when definitely there will be some sort of payout. Okay. The bottom line we know is that being a trustee is a responsible position to hold. We must encourage the firm belief that it is a privileged role and definitely upholds the aspirational notion of civic responsibility. We all know that. And I think from my side, I definitely think that it's absolutely imperative that trustees are given a certain degree of leeway, because without that leeway, nobody is going to want to be a trustee. And I think that at the end of the day, we don't want to see executive managing agents taking over every single building in Johannesburg. There's a place for executive managing agents, but I think trustees with the correct knowledge, the correct kind of training, I think you can really run a good building as long as you're aware and you've received some sort of training. Now, I'm not sure if there are any questions. We have a few minutes left to the end of this presentation. If there are any questions that anyone would like to ask.
Marina.
Yes. Hi, Nico.
Marina, I just want you to recap a bit about installing, for instance, prepaid water meters.
Yes.
And that is what I hear is a special resolution requiring 75% positive vote.
Yes. Let's just go to, carry on.
What happens, you see, we are sitting right now with that decision or resolution to be taken, and we have spent 3 years to get our building ready because we had shared water tanks. Now, every flat is having their own individualized water point, so it can take a water meter. But
Yes.
the people that are the most abusers of water will obviously vote against the installation of water meterage.
So Nico, let me just recap with that. And I'm going to just look at the actual management rules. That's management rule 29.4. So the prepaid meters are different to standard meters. A standard meter requires an ordinary resolution of members to install water or gas or any other meters. But a body corporate may, on the authority of a special resolution, install separate prepaid meters on the common property to control the supply of water and electricity, provided that all members and occupiers of sections must be given at least 60 days notice of the proposed resolution, with details of all costs associated with the installation of the prepayment system over the next 3 years. So it's quite a big story. If prepayment system referred to is installed, the body corporate is responsible to ensure that the system does not infringe on the constitutional rights of section occupiers to access basic services. So within that 60-day period, you have to give all that information. Look, it's a democracy. If people don't want to give a special resolution, they're not obliged to. They can't be forced to. The only option you've got then is to go to the Ombud and to try and overturn that resolution with the Ombud's decision. And the Ombud would then look into the details, the complexity, the money situation, the financial situation. I always say in sectional title, people will look at me outraged. Clients will say, yeah, but I mean, that's not fair, Well, it's a democracy. It's a democracy, and people have the right to run, you know, the building as they deem fit. But we do luckily now have this sort of embargo provision where the ombud can come in.
Okay. Now that clarifies it for me well enough. We have, for instance, owners that are here maybe once or 3 times a year, and they are
Yes.
obviously not happy to share in the monthly water usage bill because there's no individualized water metering.
Yes.
The other part of the question is, if a complex or a sectional title scheme is able to ring fence what is communal water usage, why can't the individual owners put in a water meter and say, I will only pay my part of the measurable common water usage and not the total?
They
Maybe I
could
must
do
make
that,
it more.
and probably, yeah, I understand. They could do that, but that would probably also require special resolution, because now you're nominating values. Because usually you run on PQ, but this would be a nominated value saying it'll all be equal, or it will be whatever, however you decide to do it. Also, special resolution would be for that.
Okay. Yeah,
Okay.
and I can see that it needs 60 days advance notice before the AGM and the proper documentation, etc. Thank you.
Such a pleasure. Such a pleasure. Right, we've reached the end of our webinar. I'm sorry if you've asked questions and I haven't answered them. I've had quite a lot to get through, but please do feel free. There's my email address. If you want to contact me, just say I'm from Women in Sectional Title. I'm always available and accessible through this platform. I'm unfortunately not going to be present at the Community Scheme Ombud Service in Durban this year, but I'll definitely be there next year, as well as the NAMA one, which I think is being held in Johannesburg next year. So until next time, keep going, keep safe, and we'll see you then. Thank you so much.
Thank you.